Hi, welcome to another episode of Kidon, War Stories on the Cutting Edge of IP Monetization. My name is David L. Cohen, and I'm the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, and defending intellectual property rights. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and many more. Today, my guest is Daryl Lim. Daryl is the H. Laddie Montague Jr. Chair in Law at Penn State Dickinson Law and co-hire at the Institute of Computational Data Sciences at Penn State University. He also serves as the Associate Dean for Research and Innovation and Founding Director of the Intellectual Property Law and Innovation Initiative. Professor Lim is an award-winning author, observer, and commentator of national and global trends in IP and competition policy and how they influence and are influenced by law, technology, economics, and politics. Among his many accomplishments, he's a founding member of the Global IP Alliance and its local chapters in Pennsylvania and Illinois. In addition, he serves as co-chair of the University Education Committee in the U.S. IP Alliance. He consults and publishes internationally on various IP and antitrust issues. Among his various accomplishments, Daryl headed the IP program at UIC Law from 2015 to 22, and in no small part to Professor Lim, the IP program at UIC Law remains one of the most respected in the country. And also since 2017, Professor Lim has convened the annual IP Law Conference, now in its 65th year, and introduced the IP Leaders Roundtable, bringing together thought leaders of different persuasions to devise practical solutions to contemporary IP challenges in the IP world. So I'm sure there's plenty more, but I didn't want to get your head too big for the camera, Daryl. Well, welcome. And so I know that you and the readers should find it obvious, you don't have a typical Midwestern accent. So you originally from Singapore, and so maybe if you could briefly describe how you ended up in IP law and in ultimately in academia and in the U.S. For our listeners.
Well, thank you, David, for inviting me. I remember in the spring of 2018, you had come to Fordham. I was on sabbatical visiting there, and we were in the cafeteria, and you told me about Kidon, this exciting new enterprise that you were part of. And here we are, 4 years later, and I'm so happy to see how it's grown and this impressive podcast series that you've put together. The journey into IP actually didn't take place in Singapore. It took place in Stockholm, in Sweden. And I think it was probably telling that for the rest of my professional life, I would be an outsider looking in, whether it's looking into the developments in international law as a Singaporean in Sweden, or looking in as somebody not trained in Singapore IP law in the first instance, looking in and seeing how those developments gel or do not with other developments elsewhere. And most recently, of course, longest chapter of my professional journey has been here in the United States, looking in from the outside and in some ways from the inside out too, of what's been going on in the US and what's been going on outside and how it affects the US. And we live in exciting times. I say intellectually exciting, but perhaps not quite in those times where we could sleep as well at night.
Yes.
But I think therein lies both challenge and opportunity. Challenge because there are so many more complex issues, David, as you yourself, your own journey, having come in atypically with 3 master's degrees and a JD from Northwestern. And Northwestern itself is known as an atypical law school because it's always been very entrepreneurial and woven in a business focus in its pedagogy. And I think where we are in this world right now, we really need to be outsiders looking in and having that sort of nimbleness and plurality of talents so that we can reach across the aisle, so to speak, reach across countries and deal with complex, multifaceted issues which no one country can solve, but even in what we do day to day, no one legal scholar in one discipline, or even a multitude of scholars, or even across the entire legal fraternity of practitioners, in-house counsel, and judges can solve. And so you and I have had the privilege of being part of this magnificent annual event called the Fordham IP Conference. And I think platforms like these at Fordham and elsewhere are needed more than ever. So I will pause there. There's plenty there already to talk about.
No, definitely. I think what I'm hearing you say, Daryl, is that your professional journey into IP, by the nature of where and how you did it, sort of made you focus as an outsider looking in or an insider looking out. And that, I think the implicit point is that's what stimulated your interest in legal academia in general, from leaving the grind, I guess, because you felt you had something to add from that perspective that you had. And it also seems that you're saying that, and I agree with you, that sort of these multidisciplinary, multi-perspective, maybe multidisciplinary is a freighted term in academia. So multi-perspective, maybe, approach to looking at issues is very important in academia, but in general. And in fact, that's one of the things that drew me to IP, was that I was always interested in physics, even though I was not very good at it, and interested in history. And somehow or another, I fell into history of science, which was fascinating, but that was sort of not broad enough. And I was looking at the history of politics as well. And then, oh, there you go, science, politics, history, IP law is perfect, because it sort of, by its nature, it's sort of a very multidisciplinary topic on its own, and despite many attempts to sort of cordon it off from other factors, it shouldn't be.
Well, what is the history of science, by the way, David? Is it guns, germs, and steel? Is it the life and times of Thomas Edison? What is it?
Well, it could be many different things. I mean, I think that's a loaded question. The history of science as an academic field, in the modern sense, is really only since the '60s, I think. And the question, there's a lot of ways that they've tried to do it. The problem has always been, and I'm just giving my little speech here. The problem has always been that it's been written by scientists who are not trained as historians. So it's been the history of problems that scientists, the history of fake problems that scientists claim were solved, that they're using for pedagogical purposes to show how to solve the problems that they're actually solving today, irrespective of whether those problems were in fact the problems that people in those periods of time were trying to solve, and those were the solutions. They're really using it as a heuristic exercise to help people understand.
I can tell you that scientists are not the only people that are guilty of that.
No, I think lawyers are too. The history of law is a fascinating thing. But now what we were interested in when I was into it was there was one fascinating scientist, a historian, who was looking at the anthropology of law, of science, and trying to understand how labs work historically and whatnot, and what worked and what didn't work. And that has some practical impact. But one of the other things that she did to do that was recreate under actual lab conditions prior experiments that were tried to do. But others were looking at other things, and I actually came into it. I was lucky enough to study with John Pocock at Johns Hopkins, who really into contextual analysis of all different things and the meaning of words and things of that nature. And I got into it because of some time at Cambridge, at UCL, where and then at UCL in London, where I was focusing on the sort of the relationship between, I was a late 18th century Britain man. And I was fascinated about the relationship between politics, science, religion, and technology. And what was great about that time was that was one of the last periods in history where you can have a unified theory of everything. and I mean literally everything, and not be thought of as a complete crank. You might have
You,
been.
you know, if anybody read your biography, they should be completely fascinated because not only do you have this um, interest and training in the classics, so to speak, history, political science, and so on, but also you've got this international perspective. You're truly cosmopolitan. I would say that I'm just like you, although I would only claim that just like you had trouble with physics. And just like you, I think I agree that mentorship is so important. We really are path dependent in that way. And the people in our lives who we are sometimes fortunate enough to have as mentors really influences what we do.
Yeah, yeah. So who were your mentors?
Well, I would say Hugh Hansen is certainly one of them. And when you gave me that very kind introduction, one of the things that you mentioned was how I'd like to bring people together from different perspectives. Really, this big tent approach. And Hugh Hansen had been doing this now for, uh, I think the coming conference will be its 30th.
Yeah.
So 30 years, even before people were thinking about IP seriously, and certainly not internationally, and certainly not bringing judges, academics, and practitioners together. I mean, why would judges and practitioners want to talk to academics anyway?
Right.
And yet he was able to carve a niche for all different perspectives. And that's why people go there. They call it the Davos of the IP world because they know that they will get candid views. So not just different views, but candid views.
Well, I think
Uh,
that's important too, Daryl, and I think it speaks to something about you that's important. Um, I always found one of the reasons why Fordham was wonderful was not just the diversity of people,
hmm.
but that everyone felt safe enough to say what they were muttering under their breath while they were working. And Hugh let them do that, and no one got shut down. And maybe it was because the judges left from their home countries and they felt safe under true ground or whatever. But I think that's something that you do as well, is that you make people that you invite feel comfortable so that you can actually have a productive conversation. Because I think you can have all the brilliant people, and I've seen this in business and in law. You can have all the brilliant people in the world, but if they don't
Hmm.
feel something, whatever that something is, they won't contribute their best.
And I think that's really symptomatic of the broader issues that we can talk about. That certainly has been plaguing the headlines, whether you're talking about with anti-suit injunctions and FRAN, whether you're talking about the COVID waiver at the WTO, whether you're talking even at the international level with the breakdown of multilateralism, wars in continental Europe, and so on. There's really a deficit of a reservoir of trust.
Yes.
And until you have that comfort that you just mentioned, I think a lot of the problems will not even be solved by the law, because if the law is really there when relationships break down, and you have that the law is the last vanguard, if you like, the last resort before you come to blows. And when laws are disregarded, and you know this because you studied the history of law, that we really are just one step shy of anarchy.
Oh, 1000%. It's sad, but my standard advice to clients when drafting agreements with parties is like, how much do you trust these people? And they ask me why, because I said paper is only as good as the people who sign it. And even then, even if you don't trust them, it's only as good as the system that's going to enforce it.
Mhm.
And unfortunately, we talk about efficient infringement and whatever, and I'm not to get into anything too loaded, but I think, and whether or not the people accused of efficient infringement are in fact being engaging in efficient infringement, but there is something in the cultural water right now that people engage in that, like, you know, um, infringe now or violate now or breach now and apologize later. And it seems to be sort of almost the culture in business, the culture in the culture now. And I think it is a macro issue that we could talk about, and that's impacting our little corner of the world too.
Yes, well, IP has always been a little bit different. I remember in Singapore when I was growing up, the IP office there had to put a very concerted effort as we were ramping up to join the US-Singapore Free Trade Agreement
Right.
back in 2003 and came into force 2004. Singapore was not the sterling shining city of IP protection that you know it today. I could walk along the street and get any number of pirated CDs and movies and so on. And it was that stage of development.
Yeah.
But they had to put out a campaign, educate the people that IP theft is theft, and really instill a different type of consciousness into the population. So when you talk about efficient infringement, which by the way is also itself a loaded term, that folks, especially I think the big tech folks, we won't name names, but I think it's all out there, really believe that that makes business sense to do that. And why pay when you don't have to? And the
100%.
problem, David, is it used to be more, I think, symmetrical. And patents, you could be on one side or the other. But I think in the tech world that is quite skewed. And so whether if you are Nokia, for example, yes, you are pro IP. But if you are somebody else that's an implementer and you're consistently an implementer, you basically go back in a sense to generics and brands. And it's even more skewed, as I understand, than that in the tech world. So without that parity, you don't really have interest without a neutral arbiter.
No, I think that's an issue. So
to find a common framework.
Exactly, and so turning to, and I'm going to go at this a little sideways, but trying to bring in like legal academia. Having started, as I mentioned, in sort of a niche academic subject, history of science, and IP. When I started IP was it 96, 94, whatever it is, when I was in law school, it was also somewhat of a niche subject in that nowadays every school has IP, but then only very few did. And my observation is both in IP but across niche subjects is when they start, you get these professors who are like cheerleaders for the field. They teach it, right? But they also are cheerleaders, and IP is great, it's wonderful, and everything like that. And then there's sort of this decadent cycle where, as it becomes more and more pervasive and in the field, and this is sort of general. I mean, we could talk about how it relates to IP, but my observation is as the subject area in academia becomes more common and spread across, you get this weird phenomenon of anti-niche subject professors of the niche subject, who are sort of like almost self-hating professors of the niche subject. And I have my thoughts, but you have these weird situations where you have professors of IP sort of arguing against the existence of IP. And I'm curious if what kind of trends you've seen in both whether you noticed that trend, but also how you've seen the history of IP academia change over time.
I think that's certainly true. You're not the first person that's observed that trend, and I think it's partly generational. You have folks that grew up, as you say, champions of the system. They saw what the world was like before. They saw the difference that having that common system of strong IP rights does. And then you have people that are brought up in a generation that are influenced by media that talk about how big bad pharma is depriving needy countries of access to medicines. You see the Business Software Alliance or record companies bringing ill-informed lawsuits that get blown out of proportion against single mothers for infringing on a few songs, and then it feeds into this broader narrative of a distrust of authority that came about probably during the hippie era of the 60s and 70s, anti-establishment mentality. And it was cool to not hit on IP, I should say, to hit IP. And you have the wellspring of support from the even younger generation who are their students saying, oh yes, of course, my professor actually understands me. And then you have the rise of the tech companies who do nothing to disabuse folks of that view. Um, Everything should be free, or everything should be close to free. And what happens over time is you have a shift in the way that both legal academia and the people who go through the system and come out see it. And so when you talk about the views of institutions, for example, like George Mason, um, they stand, if you like, polemically opposed to other institutions like Berkeley, for example, that are known to be, if you like, more anti-IP,
Yeah,
or that itself is a loaded term. So I should say a different view of IP
yes,
uh,
yes,
than folks at George Mason have. And it's not pluralist. I mean, it's not mono uh, chromatic in that sense. I think there are many nuances along the
of
way.
course.
But I think that generally has been the trend. And I think it's symptomatic of a broader narrative and a broader need to have the people that believe in IP convincingly explain to their constituents why IP should be respected and why you should have these rules in these areas in this way, and how we are also taking care of your concerns. And I think that's been an effort that has been somewhat lacking. The Western style of conflict resolution is it's more who pounds the table more loudly. And I think this is where we can learn from, if you like, softer, more consensus driven Asian styles of finding consensus through negotiation, through quiet understandings, and through a better alignment with underlying interests. And that takes relationship building, it takes patience, not really thinking in terms of news cycles or elections every 2 years.
Yeah. No, I think that's fascinating point. And so just I'm going to have one tangent, but then one sort of question. So there was some fellow half jokingly, it was very popular in LinkedIn, created flowcharts of negotiation styles by countries. And it was you should I have to be able to find it, but it actually was painfully accurate and hilarious at the same time, and sort of supports a lot of what you're saying, but it was just in graphical form. But so sort of the real question that I had was, another trend I've observed in legal academia, both because I wanted to be an academic myself at one point in time, although I like to say I'm a frustrated academic, so now the world has to suffer, and I
Not too
see
late, not too late, David.
not too late, right? But maybe, but too many obligations presently. But
We can get you in as an adjunct. Think about it.
all right, all right. We should talk. We'll talk. But I've also observed this is that it used to be that back in the glory days or the original days or whatever, the golden age, however you want to talk about it in a non-loaded way, that most professors were practitioners at one point in time.
Yes.
And if they weren't practitioners, they were, superstar associates who ended up um, going into what's it called, the going into academia at some point. Now it
Through
joking,
the clerk system. So they would
yeah,
go
through the
through
clerk
the
system,
federal clerkship,
very
Supreme
federal
Court,
clerkship, and then they
and
worked
then
for a few years,
academia.
and yeah, and there were certain firms that were known. Like if you didn't want to be partner, you went to become a professor. Now it seems that you got to have like 3 or 4 PhDs in obscure topics that may be completely unrelated to law to become a professor of law. And I wonder, of course, the cynical view is that legal academia is chafing against the fact that law school is a professional school, and they want to be academics like everybody else, et cetera, et cetera. And so they're going into the basket weaving type. This is the cynical view, the basket weaving approach to other topics that try to find how many angels dance on the head of a pin. But there definitely is a sense that there's a disconnect between what and things that your programming definitely does a lot to disabuse that disconnect or to attack that disconnect or whatever you want to say, whatever verb you choose. But there's definitely a sense that what academia does in the law is very different from what practitioners need in the law. Sometimes in amusing ways and sometimes in harmful ways. And I'm curious if you observed that trend and what your thoughts were and how it
Well,
might relate to the general issues we were just talking about before.
I think that's an excellent question, David. Let me relate my answer to the title of your podcast, which is War Stories. And I'll tell you that my personal story reflects that trend that you just observed. I started at John Marshall Law School, founded 1899, and it was itself an institution that was built on the backs of practitioners who gave of their time really as adjuncts. And it was not until much later on in its history that you had full-time law professors, and even then was law professors who also practiced, or law professors who trained their students who were marginalized, whether at that time women or minority races, etc., and were very proud of their evening class. And so really it was a school of opportunity, and by necessity, in order to give their graduates a comparative advantage, they had to be able to tell employers, please hire our graduates because they are practice ready. And that has become a tagline for the school.
Right.
And because they were practice ready, and people have told me this over the years, they look differently at John Marshall graduates, because when they come in from day one, they know how to do some basic things, which some of the better branded schools, they don't quite come in with the same type of
Yes.
skill set.
Yes.
And you don't really need to pontificate about the policy reasons for this or that rule. You want to get the job done. And so UIC acquired John Marshall. It's now facing, I think, a more tensions that are more common to other institutions, other law schools that have gone on this journey, which is how do you integrate with the broader family of
Right.
scientists and theorists. And law schools are not quite the cash cows that they used to be. And you've got to think about grant applications, and therefore you need to be able to talk to your colleagues in a way which makes sense to them.
Right.
Also, there's that pressure from the better ranked academic institutions, law schools, that pride themselves on theoretical thinking. So I was in Chicago for now last 10 years, and we always had activities of Loyola and Northwestern and Chicago Kent. And University of Chicago wasn't quite part of what we did, not just because they were located in Hyde Park, but really their focus was not quite in the things which we were focused on. And whether it's a combination of intellectual snobbery or just a different bent, it was not something which gelled. And but at the same time, that's how every law school wants to be. They want to be one of the top 10 or top 20 law schools in their country. So what do? You look at those schools that are in that ranking and you try to emulate them. And so on and on it goes. You produce a whole nation wide population of schools which pride themselves in thinking a certain way. Now, I should say that there is a redeeming effect to that. And it's not all bad, because it forces in this interdisciplinary type thinking that we now have to engage in. Uh, you need to learn different skill sets. For example, right now I'm at Penn State Dickinson Law, and Dickinson Law itself was a standalone law school that was um, acquired by Penn State University. And I'm a co-hire, as you mentioned in your introduction,
Right.
of ICDS, dealing with big data and AI. So I now have the opportunity to bring facts and data to legal policy making, legal doctrine. And that's wonderful, because it brings the discussion out from a he said, she said to here, look at the numbers. And look at the numbers not just from a small population set, but look at the numbers really from across a state or across a country. And look at issues like diversity, equity, and inclusion to say how we can bring people who are otherwise minority groups without access to the patent system or the trademark system, or what difference that might make to the GDP of, say, Pennsylvania or the United States. And I mean, this is a whole new dimension of legal scholarship, which is just starting to bloom, and which I think will characterize how academia will look like probably for the next decade.
No, I think that's really fascinating, and big data is coming up in very interesting ways. My father is historian of medieval eschatology, believe it or not. And
So it sort of runs in the family, I see.
well, he was a businessman and an economist before that. But yeah,
The polymath ability too.
yes, indeed. And one of the things that I like to read some of his stuff, and one of the things that I see is applying big data to the spread of manuscripts in the Middle Ages and earlier, because you wonder how ideas spread. Well, they show you how ideas spread because you now know where the manuscript was at a particular point in time, and sometimes you even know who was given access to it. And it's really fascinating to see these kinds of things. And so big data and those can be used in all different interesting ways. But so you're touching on something here that I think is important. So we sort of talk about now the role of the IP professor in society. There was a cheerleader for IP, but and then maybe not so much anymore, and talking to themselves. What do you see sort of the role of an IP professor? What should be the role of an IP professor in society, both within the legal society and the larger legal community, but also in the broader society at large?
Well, I think the important first thing to highlight is that there is no one definition or one skill set or one role. Different IP professors bring to this label called being an IP professor their own journey and
Right.
their own interests and their own skill sets. And I think that's a good thing. You have a plurality of IP professors focused on different things and in a different way. My journey has been one of being an outsider looking in and seeing the importance of bringing people together. And so that's what I bring to how I teach IP law and how I pursue interests that are related to being a professor, including organizing conferences, including talking to you and sharing what little I know and what little I believe about how the world might be improved in the world that the spheres that we live in. And others address other issues which are equally important, but which I have no talent or time for. And these are important interests. And I think in the framework of a marketplace of ideas, hopefully you have that specialization that meets a need. And if the need is not wanted or the skill set is not wanted, then the market shifts. I don't think that the market is quite working so well for the reasons that we just discussed previously. Right. And we might be institutionally rewarding behavior which is not particularly socially productive, but which may be good for rankings and other reasons. And I think that then invites us to consider whether we should rethink how we reward particular institutions or particular skill sets or particular interests.
No, I think that's a fascinating point. And so back on the outsider looking in point, one of my prior gigs, I worked for the Law Society of England and Wales, and my job as the outsider looking in was helping advise people from various common law jurisdictions how to practice in other ones. And what it forced me to do is get a better understanding of how the teaching how to be a lawyer in different jurisdictions worked. And it's very different. and there's this bias that most people have, especially in a country as big as the U.S., but I think everywhere. It's a very parochial bias. What exists. The naturalist fallacy. Because it exists, that's what's good. It's good, and you might not even know other things that exist. And I'm just curious: have you thought about generally how law is taught and lawyers are trained in other countries, and how IP is taught in other countries or jurisdictions, to be technical, because they are different within different countries, are taught, and how, what you sort of see that's good about it that might be worth bringing to the States, if you could, but also, by the same token, what you think that what you've learned there that shows, hey, what we're doing in the U.S. in fact isn't so bad, or
Well,
pretty.
I would say my own journey reflects that. Here's another story. You asked where I first started learning IP was at Stockholm University, and they used a British textbook by Cornish. So
Yes, I know that
Cornish,
one. I think
yes,
I have it somewhere.
and so the day in Singapore. Um, so in the European system, they're a lot more textbook focused. You have a learned scholar that distills what you need to know about the law into a 500-page treatise, and that's it. In Singapore, they give you a thick stack of readings in your mailbox, easily topping 1,000 pages per subject each semester. They don't curate it for you by pages, and they normally give you more than you could possibly read or need, but which could be relevant. And then it's up to you to sort through why it's relevant, how it's relevant, and think like a practitioner, because nobody's going to do that curation for you in practice. In the US, when I first came for my graduate education, I was intrigued by the casebook system, which tries to, in a sense, find a balance between the European model of having a textbook and then having just cases and articles and you go sort things out. But at the same time, that was complemented by, in some sense, the Socratic method. In other ways, more of not quite cold calling, but warm calling. And you are not made to shiver in your seat when your name is called, but you actually are invited
Well,
to
I
engage
had
into a
I had a
discussion.
Kingsfield like
So
professor
you have
once.
my condolences.
Yes.
um, and I left class usually not knowing, having been wonderfully entertained and stimulated by the discussion, but not knowing then, so what is the point of all of this? How am I going to answer the exam? And in my own approach to legal education, I've tried to meld the best of the three. And well, I will leave it to my students to tell you whether it's worked or not.
Right.
But I think the question that you asked has an underlying assumption, which is an important one, that no one system has the monopoly on wisdom, but nor should we think that having arrived, we can't do better.
Right.
And I think one of the great strengths of the United States is its ability to draw folks from all over the world and actually then enrich a country by those very diverse experiences. And you can't quite do that in many of the other places, whether for cultural or linguistic reasons, or really for economic and public health reasons, such as you might be bombed, or you might have to live a very different type of lifestyle,
Right. Right.
too austere, I think, for most. And so I think it's something which should endure in this country, and I think it will be a good thing.
No, I think that's great. It's interesting. There's that old saying that at least it relates to in many areas of the law, especially IP law and antitrust law, which are your expertise. What if the United States sneezed, the world caught a cold. In other words, that whatever was going on here in the States would have basically be either aped or reacted to negative, in reacted to elsewhere. But the reaction would be based on what happened in the States. Whereas now, I think you have these emergence of very, very strong movements of their own making and own that come from their own sort of traditions in Europe, in China, uh, in South America, and elsewhere, both in IP and in antitrust, among other areas, of course. And on the one hand, we can decry the multipolar world from a peace and harmony perspective, but it's sort of interesting that from the topic that whatever you want to call the topic we just talked about, and that actually might be a good thing in that you're starting to have different experiments in how to govern people that could theoretically be in communication with each other, and different experiments in how to educate the lawyer class that could be and I'm just sort of curious if you've observed that and how you think that impacts what we were just.
Well, I was giving a talk to a group of in-house counsel and practitioners not 2 or 3 weeks ago, and they asked me to talk about current developments, and one of the things I touched on was the Biden administration's withdrawal of guidelines, actually, on injunctions for standing essential patents.
Yeah.
And a lot of the reaction, positive or negative, focused on the old narrative of, well, is this anti-patent, pro-patent? Should antitrust have a role to play in how you exploit your patents? And I realized that that type of discussion was so 90s, or if you want to be charitable, so 2000s. The world has moved on. In fact, the world is the whole point, I said to the audience, because really, who cares where the final points of this is if you don't also take into account the third dimension, which is that you need to have rules that make sense to your country's strategic interests and national place in the world if you don't want them to take your lunch. And how much do people actually know about how business is done in China, or how people think in China, or how the government is run in China? For many in the audience, it was the first time they actually thought about it, and I was shocked because these are senior executives at multinationals or senior lawyers advising these senior executives at multinationals. And I think it really is a function, perhaps, of the fact that day-to-day people are just so absorbed in fighting fires that they don't really have a chance to think both strategically and in an integrated way. And I think it's really behooves perhaps academics. If nothing else, we have more of the time and the interest in looking at these issues broadly. But also then the academics need to have a role in positioning themselves so that when they say something, it's relevant. And they're not just talking about, as you had vividly put, how many angels can dance on the head of a pin.
Yes, no, I think that's a beautiful thought that the academia, I guess, has to stay in conversation with practice, such that when they do speak, they're taken seriously, as opposed to jocularly, but also mostly because they by the structure of what they do, they have the opportunity to take the broader view and the deeper view of things, and they're not putting out fires every day, or at least we hope they're not putting out fires every day. Although they may with staffing costs and stuff like that. That's a beautiful idea. Transitioning now to the second part of your title down there, Dickinson Law. So it may be a trade secret. That was a joke, but I'm curious what your hoped for sort of short-term and long-term plans are as the new professor at Dickinson Law.
Well, I just started 2 weeks ago, and certainly for the next several weeks or months, I will focus on one thing, which is to listen and learn. I don't assume that every institution is the same. Dickinson law itself has a long and proud history that stretches even further back than John Marshall. And it's the oldest university in Pennsylvania. It's also in a different part of the country. It's in the Keystone State.
Right.
Part of what drew me there was this opportunity to really think regionally right from the start. How can I join, being in the Keystone State, activities in New York and Pennsylvania, Maryland and DC together? And you talked about the Global IP Alliance and the US IP Alliance, and this type of thinking of bringing people together, not just the lawyers and judges and even academics, but also the creators, university tech transfer officers, K to 12 folks, and really thinking about IP from a multifaceted perspective: education, exploitation, DEI, and then integrating with government, and government not just in national governments like we do, because DC is certainly at the hub of it, but also internationally. So with WIPO, and through that the United Nations, and also through regional groupings. So I think bringing the conversation to full circle, it really is an exciting opportunity to connect to solve the global commons problems. So whether it's climate change, whether it's the digital economy, and to create a better framework that is, I think, more relevant for the times that we live in, that will help foster trust and hopefully leave our successors with a better system than we inherited, which was good for its time, but I think worth rethinking.
Oh, that's wonderful. That sounds exciting. How many professors are there in that teach IP law at Dickinson?
Well, it depends on how you count. We actually have quite a good number, given
Wow.
the small faculty that we have. The dean herself is an author of several IP casebooks. She's, for administrative necessity reasons, not quite as involved, I think, in IP as she used to be. But we have quite a number of scholars that approach IP from different perspectives, including cryptocurrency,
Oh, wow.
traditional copyright, and I do patents, but I also do other areas. So I think it's quite diverse, both in terms of the subject areas, but also in terms of the penumbra that we look at. And I
That's just a
think
lawyer
it's a
word.
good community. Yes, but also the fact that we are not too far away from other law schools, and there are these regional programs, I think is quite an exciting
Oh,
time
definitely,
to be
definitely.
in that area.
Yeah. No, and are you how will you be teaching this semester, or are they gonna let you
I
set?
will be teaching the semester. Amongst the many other things I'll be doing is really getting in touch with the 1Ls. And there's no better way, I think, to get a sense of the pulse of the institution than to be involved in a 1L course.
Right.
And then also I'll be teaching upper level courses in the spring semester, antitrust and patents, which are my subject areas, but
Yes.
also then allows me to look at how I can grow opportunities beyond the classroom for students in those areas, because I am also the founding director of the IP initiative at Dickinson Law. And that means an initiative means a new vanguard, a new way of thinking about programming and staying relevant, I think, in a world that's changed. Legal education has changed, and we need to change with it.
That sounds very, very exciting, Daryl. Well, so I wish you the best of luck. It sounds exciting. Let's keep in touch, definitely, especially since now you're much closer to me. Although it was easier to fly to Chicago than to drive to Penn State, but but maybe not nowadays with the
We
airport.
will bring Dickinson Law to the heart of government and to the heart of industry. So it might be at an address or a zip code that's near
Close
you
to
before
me.
too long.
Well, in any event, let's stay in touch, and thank you so much. This has been wonderful. I really appreciate all your time, And to our viewers, please feel free to reach out to Daryl at Penn State. What's the best way to get a hold of you?
Ask Google.
Ask Google. All right. Google has it. You have all your contact information on your various websites. Yes. Excellent.
Oh,
And
I should do a plug. Well, I do have a personal website, lawdaryl.com. So if you want to go there, you can reach me through my website too.
excellent. Excellent. I'll try to include a link in that in the blurb with the video. Well, thank you again. And it's been lots of fun.
My pleasure. Thank you.